Okay, welcome back. In our last class, we discussed the novelty requirement for patentability. And specifically, we discussed the prior art element of the novelty requirement, or rather discussed briefly how the way we determine whether or not a patent claim is novel for the purpose of patent protection is by determining whether or not there is any prior art that reads onto the claim in question. And of course, in order to count as prior art for the purpose of destroying novelty, the prior art has to actually anticipate every element of the patent claim. That means it has to be the same as all of the elements of the patent claim, and it has to actually enable a FZITA to practice the patent claim in question. Now, there's several different kind of sub-doctrines within the concept of prior art for the purpose of the novelty analysis, and that's what we're going to be looking at today. So one important element is the printed publication requirement. And that goes to the question of, what counts essentially as disseminating knowledge of the invention or discovery. That's the subject of the patent claim in question for the purpose of creating a prior art bar to novelty. In other words, what kinds of disclosures can make something prior art? So in the Klopfenstein case, what we have is two inventors. They've applied for a patent on a method of fabricating extruded soy cotyledon for food products. Sounds delicious, right? And the question is whether or not their claims are barred by prior art. Now, what's the problem here? Well, the inventors themselves presented the core discoveries behind the patent claim. In other words, they disseminated the information necessary for a FZITA to understand how to make or how to practice the invention in one or more poster presentations at conferences for people in the cereals science industry, right? Now, what does that mean, right? Basically, they created visual displays that were set out at the conference that were available for anyone who was walking around in the conference area, typically a hotel, to see those poster presentations and thereby get the relevant information. And those poster presentations were set out in public at these conferences more than a year before the patent applications were filed. So if there's a printed publication more than a year before filing, so after invention but before discovery under the 1952 Patent Act standards, then the disclosure is a disclosure of prior art, and the patent claim is non-novel and therefore invalid. So the question was whether or not these poster presentations counted as a printed publication for the purpose of the Patent Act, and the court said yes, right? Essentially, it said, look, this is a location where FZITAs in your field are going to go, right? I mean, this is precisely the kind of place that you're going to find FZITAs in extruded cotyledon, right? And the fact that you made it publicly available is enough to make it a printed publication, right? It doesn't matter that it wasn't specifically highlighted or indexed in any way. It doesn't matter whether anyone actually looked at the posters or not. The point is they were there and they were available, and that's enough to make them a printed publication for the purpose of the prior art analysis. Now, the book also notes, as we discussed previously in relation to the metal alloys case, we discussed the Banner case that we discussed in our last class, right? How did the court know about these poster presentations? I mean, after all, it's not like there was any record of them. Well, it knew about them because the inventors, the applicants, told the patent office about them. They had an obligation to do so, and And they did. So it really kind of underscores the extent to which inventors, patent applicants, have a affirmative obligation to disclose all relevant information to the patent office. Okay, so in addition, there is a public use exception to patentability, or prior art by virtue of public use of an invention or discovery. So in Beachcombers v. Wildewood, we have the inventor of a kaleidoscope who wants to claim patent protection over the invention. The problem is that the inventor had demonstrated the kaleidoscope in question at a party. Right now, here's an example of the inventor's kaleidoscopes. Now, was it a public party open to just anyone? No, right? It was obviously a party that consisted of, friends and their acquaintances. The problem for the inventor was that no one had any obligation to confidentiality, and they were able to examine and learn the nature of the invention in question. So the court said, for the purpose of the public use limitation, or the public use standard for prior art, demonstrating the kaleidoscope at the party was enough, right? It doesn't matter that it wasn't for the general public. You showed it to people who didn't have to keep the secret. That's a public use for the purpose of the Patent Act. Okay, and then do we also have the on sale exception, right? So if you haven't demonstrated to the public, but you're offering to sell it to the public more than a year before the application, that'll do it too for the purpose of the prior art analysis. In a Pfaff v. Wells Electronics, the patent in question was over a socket for an integrated circuit. Essentially, Texas Instruments commissioned Pfaff to create the relevant socket. He did up some drawings, sent them to Texas Instruments. They signed off on the drawing, and then he went ahead and manufactured had manufactured, according to his specifications, the IC socket in question. When he filed he received a patent, but then the question was whether or not the patent was valid, right? Whether somebody practicing the patent without his permission was an infringer. And the court said no. Right? Why not? Well, the patent socket was on sale, according to the court. Now, Pfaff says no, it wasn't. Right? I didn't actually deliver any sockets to Texas Instruments until less than a year before filing my application. The court says that's not what counts. Right? I mean, you sent them the designs that disclosed the information and caused them to want to purchase the sockets in question more than a year before filing the application. And that's what we're talking about when we talk about something being on sale, right? You reduced the invention to practicability, right? By preparing these drawings and spec sheets. And the fact that TI put in the order was sufficient to mean that the invention in question was for sale. After all, TI knew what it was buying, right? And so it was by virtue of it having purchased these sockets that made the sockets on sale, even though you hadn't actually fabricated the sockets in question yet. Because of course, what patent law protects is the invention or discovery, not the reduction of that invention or discovery to practice. So the patent isn't over the sockets themselves, but rather over the inventions or discoveries that are claimed and then realized in the sockets themselves. So it doesn't matter that the sockets hadn't in fact been constructed, and should be more obvious when you think about the fact that, Pfaff never had to actually make the sockets at all, right? He could have applied for patent protection without ever having reduced the invention or discovery in question to practice. Okay, and there is, however, an experimental use exception to the public use and on sale doctrines. What does that provide? Essentially that, if you're demonstrating or performing the invention or discovery in question for the purpose of determining what the best way of actually realizing that invention or discovery in practice will be. In other words, for the purpose of applying for a patent and determining what the patent claims are going to look at, then that is an exception to the treating that demonstration as a public use or the invention being on sale for the purpose of the prior art analysis. So what happened here? Klopfenstein and Wrapmaster are both in the business of producing, or rather doing maintenance, essentially on oil pipes. And Klopfenstein has applied for, or has received, a patent on a particular method of repairing pipes, oil pipes, by wrapping them with a filler material while that material is still workable. And Wrapmaster, being sued for infringement, defends himself by saying, this was publicly used more than 1 year prior to your application, right? This is barred by prior art analysis, so it's an invalid patent claim. And Klopfenstein comes back to saying, no, we did demonstrate the method, but we were doing so for the purpose of experimenting on the method itself in order to determine the best way to do it. And the court essentially rejects their argument on the merits. It says, no, you were just showing people how this worked, right? You weren't trying to refine the invention or determine how to accomplish the invention's goal most effectively. You were just showing people how it worked in order essentially to try to convince them to buy it or to hire you to practice the invention for them. And that's not an experimental use for the purpose of the prior art analysis. That's just a demonstration. And you haven't produced any evidence that you were in fact experimenting for the purpose of the patent application at the time of the demonstrations in question. Okay. Now, we've been talking about patents and prior art under the Patent Act of 1952. As you know, the AIA of 2011 has affected the novelty analysis, right? Most fundamentally by shifting from a first to invent to a first to file standard. And that shift comes along with increasing incentives to file as quickly as possible, right? To disclose the invention and file the patent application as soon as possible by making third-party disclosures during the period between invention and application, prior art in ways that they weren't previously. So prior art in terms of invalidating the patent claims. So in other words, under the AIA, there's a very strong incentive for inventors to file their patent applications as soon as possible, and certainly not to disclose anything about their inventions or discoveries publicly prior to filing a patent application.